to welcome all of you here. My name is Julie Rossicki. I am the CEO of ISS USA, and it's my distinct privilege to welcome everyone to today's webinar, Cross-Border Family Connections, 7 Principles to Protect Children's Rights in Practice. I'm also very happy that today is International Social Workers Day and the kickoff to International Social Worker Week. It is not a coincidence that we scheduled this webinar for today and this week. Social work has been a core practice for the ISS Network for soon to be 100 years this October. And to learn more, we have an entire website devoted to our history. And Sabina will go ahead and put the link in the chat. So if you want to learn more about ISS and our 100-year history, please feel free to check us out. We had more than 430 registrations representing 58 countries. We're thrilled that there's so much interest in this topic. Thank you all for joining us, whether it's your morning, afternoon, or evening. We're encouraged by your interest. Just a couple of housekeeping items. Everyone will be on mute, but there is a Q&A function at the bottom of your screen next to participants, or at least that's what it looks like on mine. So we encourage you to ask questions using the chat function, using the Q&A function, and we will answer them at the end of the webinar. We will go through our presentation first, and then we're going to have a brief survey to get your feedback. And then following that, we will have a Q&A for anyone who's able to stick around beyond the hour. And we really do hope you'll stay. And we will be forwarding links to all the materials after the webinar as well, including a recording. And I just want to let you know that we will be recording this webinar. So just to make sure that we're doing that now. I'm very excited to introduce and recognize the ISS team that has worked across many time zones, early mornings and late nights for some, to put this webinar together. We have Sabina Tedrenko, who is facilitating the webinar from the ISS General Secretariat in Geneva, Switzerland. Carolyn Hausman and Jasmine Rai are at ISS UK in London. Sylvie Lapointe is joining us from ISS Canada in Ottawa. Elaine Weissman, Susan Jacobs, and I are joining from the US in Baltimore, Virginia, and Annapolis, respectively. Jeanette Wallenstein and Giovanna Riccardi are from the ISS General Secretariat International Reference Center for the Rights of Children, and they're joining from Germany, I believe, both of them. And also I want to thank Damon Martin from ISS Australia, who's in Sydney, and Miyako Ishikawa from ISS Japan in Tokyo, who in addition to contributing to this webinar, are spearheading the delivery of the webinar to the Asia Pacific region on Thursday. So if anyone wants to see this again in a completely different context, we encourage you to join the webinar on Thursday. Next, it is my distinct pleasure to introduce Ambassador Susan Jacobs. Susan has been a board member of ISS USA for almost 7 years and the chair of the ISS Governing Board, elected by the International Council for the past 6 years. Welcome, Susan.
Thank you, Julie. I am delighted to be here with you today. I'm not going to say good morning or good afternoon because it's both. I'm really excited about this initiative. I think that it shows that ISS can continue to grow and evolve as it seeks to protect the rights of children and families around the world. We have been doing this for almost 100 years. And when we started, our basic principle was that we would provide these services without regard to race, religion, creed, or anything else. It was just to help people that were in need. And throughout the years, we have expanded our programs. We look for new areas where we can be useful, whether it's finding the origins of children or in defining surrogacy and working with that. And it's really exciting that as we celebrate our 100th year anniversary this October, that we are not like old dogs because we have learned some new tricks and we have learned how to adapt and to evolve. And it makes me so proud to be part of this organization because you all devote so much time and energy and goodwill to making the world a better place. And there are few organizations that can make that claim. So I am very excited to be with you today. I think that it is important that you have recognized that there are people in need who might not be able to avail themselves of ISS services if they had to pay a fair price but unaffordable to them, and that you are figuring out ways so that they can benefit from ISS's competence and care and make their lives better. So thank you very much for what you do. And I'm going to turn the podium back over to Julie. Thank you very much.
Thank you so much, Susan. And as Susan mentioned, ISS's focuses efforts on families separated by borders. And while most countries focus their efforts domestically, ISS globally has over a 100-year history, accepted the unique challenge of how to apply many of the good practices that all of you have adopted in your respective child protection systems in situations when a child and family are separated by a border. So first, let me take a minute to define what is equity and permanency, because I think this is the crux of everything that we're going to talk about today. And we're going to give you lots of examples based on the 7 principles that we come up with. But what is equity and permanency? Equity and permanency refers to principles and subsequent policies of child protection practice that prioritize the exploration of family placements without discrimination of any kind. They empower child protection partners globally to have a child's rights approach, ensure all family placement options are explored for any child who can no longer be cared for by their parents. They create access and connect with a child's extended family, both locally and overseas, to provide the best opportunity for them to be raised with a strong sense of identity, belonging, roots, and culture. And when we say raised, we also include maintain relationships. Even if a child's ultimate placement is not with their family overseas, we encourage that that child maintain the relationships with their family no matter wherever they are. So why should we worry about equity and permanency? And why should we worry about looking for family both within a country and outside of a country? Globally, the International Organization of Migration, IOM, found that 281 million people are living outside their country of origin back in 2022. And given the events that have happened since 2022, we can assume that this number can only be significantly higher and continues to rise every day. As a result, millions of children have family connections that cross international borders. Research conducted by ISS members, and there's 2 papers, one written by ISS USA, one written by ISS UK, that the links are placed in the chat, show that only a small percentage of children in care have an international family placement option explored. There's a dearth of policies to support international family finding and engagement at a national, jurisdictional, or institutional level. Child protection practitioners may be unsure of how to abide by foreign regulations and laws associated with securing permanency for a child when working outside of their jurisdiction and without clear guidelines informing practice. And finally, there are deeply rooted racial and ethnic biases that contribute to the significant hurdles that children of color face in achieving permanency with family as compared to their white counterparts. While race, ethnicity, or nationality alone cannot be an indicator of whether a child has family overseas, failing to consider these elements compromises the ability of child protection systems to seek placement options that prioritize a child's sense of identity, roots, language, and culture. So, without further ado, I'm going to turn this over to Jeanette Wallenstein to briefly touch on some of the guiding legal frameworks for cross-border placements. And then Sylvie Lapointe, Carolyn Hausman, and Elaine Weissman will share more information about each principle and some examples from our cross-border work. And finally, we will ask you to complete a brief survey where we have a QR code, so it'll be easily accessible. And then we will open this up for discussion and questions for all that can stay around. So thank you so much. And Jeanette, I turn it over to you.
Thank you so much, Julie. Sabina, next slide, please. You can go to the next one. So cross-border family placements, they are a form of kinship care options. In international texts, kinship care is defined as family-based care within the child's extended family or with close friends of the family known to the child. As an alternative care option, kinship care is intended to be of temporary nature. Kinship care can be both a response to a child's separation from their parents and a way to prevent family separation. It refers to a variety of different care arrangements and can take various forms depending on each country context. So what are the international standards that we need to be aware of when we talk about children and kinship care? The starting point are certainly the provisions of the Convention on the Rights of the Child. For instance, Article 20 provides a non-exhaustive list of alternative care options and states that when considering solutions, due regard shall be paid to the desirability of the continuity in a child's upbringing and to the child's ethnic, religious, cultural, and linguistic background. And this idea is, of course, repeated throughout various provisions of the CRC. The UN Alternative Care Guidelines, as well as the 2019 resolution on the rights of the child, recognize the importance of kinship care for children around the world and give guidance on how kinship care arrangements should be dealt with in order to protect children's rights concerned. The 1996 Hague Convention on Child Protection provides a legal framework for a cross-border kinship care placement by setting up a mandatory consultation mechanism prior to any cross-border placement. And then there are also important key resources that you might want to look into, starting by the Moving Forward Handbook of 2012, as well as more recently, the Global Kinship Care Guidance. Next slide, please, Sabina. So to summarize, just a few key considerations that are foreseen by international standards concerning kinship care. Children should only be placed into kinship care when it is necessary to separate them from their parents and when it is the most suitable form of care to meet their needs. Kinship care is the first option that should always be explored when children become separated from their parents. Decisions must be made on a case-by-case basis, taking into consideration the child's best interests, his or her wishes and needs, as well as the wishes and needs of prospective carers. The state has a role to play in supporting both parents and kinship carers to fulfill their responsibilities. And when we talk about cross-border placements, then any cross-border decision would require a formal decision made by competent authorities concerned. The decision should be based on a solid legal mechanism, such as the one foreseen by the 1996 Hague Convention, with ideally additional safeguards that would allow for effective cooperation and communication between concerned authorities, that does not only ensure a proper and due decision-making process, but also the preparation, the monitoring, and the follow-up post-placement. And decision should be made by informed and trained professionals, including but not limited to child protection authorities, immigration authorities, staff of diplomatic missions, really to evaluate the necessity and suitability of an international kinship care placement for a child. Next slide, please. So now I hand over to different ISS colleagues from all over the world who will dive into the 7 principles of the equity and permanency paper and really illustrate each principle with case examples and recommended practices on what ISS believes is needed to fully make use of the benefits of kinship care when it comes to cross-border placements.
Hi, everyone. I think that starts with me, so you can go ahead and go to the next slide. So I am kicking off with our principles. I think the paper that this team put together has been shared, and if not, we'll put that in the chat. But Carolyn, Sylvia, and I will be presenting each of the 7 principles that we've developed, along with some recommended practices and case stories. So seems like a fitting start that our first principle is children's rights. And just to read out how we've written it here in the paper, it is the child's right to live in a safe and stable family home environment, for all decisions to emphasize the best interests of the child, and importantly, for the child to be afforded the opportunity to maintain their identity. Every child also has the right to participate in decisions that affect their life, permanent placement options included. And go ahead to the next slide. And I'll highlight a couple of the recommended practices that we put in the paper as well, and those include that protection agencies implement clear policies that are underpinned by a child rights approach to ensure family and kinship placements are explored and prioritized, that they involve and promote the child's voice in decisions that will affect their life, and that discrepancies in legal effects that different forms of family placements can have in different contexts. Next slide. So we thought we'd go through with each of these practices and talk about some of the actual cases that we've all worked on that really bring some of these to life. So I'll share the story of a case we worked on in the US with 2 half-brothers who came to the United States from Honduras with their father. Their father had struggled for many years with substance use, and ultimately, after a couple of years in the US, the protection authorities became involved with the family when they found that children were being left home alone, that there wasn't enough food in the home, they weren't attending school. At the time, the kids were about 6 and 9. They had no other relatives identified in the US, and so authorities at the time placed them in a non-relative foster home while looking for more permanent options. So we became involved with the case when the foster care agency asked us to help engage with the mothers in Honduras. So both mothers, these are half-brothers, remained home in Honduras. And so we began the process of working with both women to engage them in home studies, get information about their respective relationships with their sons, their caregiving capacity, their family resources, personal resources, community resources, all of those things that we look for in home assessments. I'm going to kind of go through this very quickly because obviously there's many more details I won't have time to share, but importantly in this case, the younger brother expressed a real strong interest in returning home to his mother in Honduras, while the older brother idea and expressed a desire not to return home, wanting to stay in the US. So if you go to the next slide, Sabina. To make a very long story short, ultimately, ISS did provide a number of services to the families and did ultimately help reunify the younger brother, the younger boy, with his mother in Honduras, while the older brother stayed in the US or is currently here. But I bring up this case for a couple of reasons. First is that we know from the caseworker who traveled with him back to Honduras that he was really tearful the whole way home, talking about missing his brother, but also sharing how much he wanted to be with his mom and how much he missed his mom. I think at the time it's 8 or 9 when he returned home. And so we think it's really important to acknowledge how complex these decisions are, and that decisions that emphasize a child's rights and best interests are not always clear-cut and really do challenge us as professionals in thinking through this work. But I bring this example also to show that the caseworker and the protection system in this case really did the important work of listening to the children's wishes, involving them in the process, working with ISS USA as well as other legal and judicial stakeholders in prioritizing a family placement and making informed decisions that respected his right to family, to safety, and also his participation in the process. I'll add, and this kind of connects to our next principle, that both mothers were assessed in the process, were engaged in the process, and are still working with them. So if you go on to the next slide, I think this is our second principle, which is equal opportunity. And this principle reads that child protection systems should create equitable opportunities for families to participate in placement decisions for their children who can no longer be cared for by their parents, including family members who reside overseas. And if you go to the next slide, I'll bring up a couple of components of the recommended practice we've included. The protection system should explore family relations and kin connections regardless of geographic location, and that they utilize technology and alternative communication methods where possible to consult with family members across borders when considering placement decisions for children. We also ask or suggest that there be a gender-based lens and that there should be an opportunity for people to be heard and provide informed consent in this process. Next slide. I want to just kind of bring back, as Julie mentioned, ISS research in a number of countries, including in the US, have found that there's really a lack of knowledge around cross-border international placements, lack of policies related to international family finding engagement. We've also found a lack of comfort in searching for and engaging with family overseas. And to me, the most amazing one in our research was the belief that family court judges would not be willing to consider with placement with an overseas relative, even a parent. And so in our research, it was about 35%. We didn't survey judges specifically, but we do know how much perception alone can affect the involvement of family overseas. So that was really significant to us. And so in thinking about equal opportunity, this principle is really about making sure that protection entities have tools to assess placement options with kin in other countries, regardless of those perceived difficulties, to ensure that children do have an opportunity to remain with family, even if that family is outside of the country. And I think Julie alluded to this earlier, but I also wanted to emphasize that not all cross-border services will result in a placement overseas, and nor would that ever be what we advocate for as a best outcome in all cases. So when we talk about equal opportunity, it's about ensuring that we can adequately assess resources wherever they are, so kids have an opportunity to be raised with family, with that cultural connection, with that sense of identity and belonging. So that's really the nature of this principle. And so if we thinking about a case to look at this and emphasize the practices, we worked on a case of a child who, in many cases, but one in particular, who traveled unaccompanied to the United States from Guatemala. She was apprehended at the border and released to the care of a distant relative, and after a couple of years, ultimately removed from that relative due to substantiated allegations of abuse and neglect. You can go to the next slide. In this particular case, the parents lived in a very remote indigenous area of Guatemala. They spoke an indigenous language and did not have reliable internet access in their home or even in their community. So as part of the service that we were invited to work on, we were asked to help facilitate actually the parents' participation in court. That was the service. There are a number of services, but this one in particular. So we worked with a Guatemalan social worker who utilized a local translator, was able to contact the family, communicate with them in their language, and kind of understand a little bit more about their situation. Ultimately, the social worker was able to arrange with a local organization in the nearest town for the family to use a computer in their office that had internet. The social worker also coordinated travel from this remote village down to the town where they could, on the day of the hearing, so they could participate and be on time. And I think actually she participated herself in the first one to make sure everything went okay. And since then, this these parents have been able to participate in every hearing. Every 2 to 3 months, they do the same journey, with the support of the social worker making the coordination, and even been able to, with the help of our social worker and our case manager, coordinate so that the court times can be adjusted to accommodate the family arriving within the business hours of this local organization, and at times what the family can physically get to the place. This is somewhere they can't even take a bus every day. So there's really been a coordination to make sure that these parents can participate in the regular hearings about their daughter. So I bring this up to say in closing that regardless of the outcome, which we don't know yet, it's still ongoing, whether the child is reunified with her parents or integrated with family here in the US, it's an example how protection systems can promote families' equal opportunity to participate in that process, and have involvement in decisions about their child, and really also how technology can facilitate that and how that's possible. So with that, I will turn it over to, I think, the next slide and the next principle.
Good morning, everyone. So I am in charge of presenting the very important third principle, which is local expertise, and it reads as such. Child protection systems should engage social workers and paraprofessionals in the same country as overseas family members for both the identification and the assessment for potential placement. Very important to say in this when we read this principle that, of course, we are talking about professionals that are recognized in their country as professionals and accredited from an accredited body, if at all possible. So that's very important to us, that when we say we want to work with professionals, that there's actually systems in place where we can actually go and verify who we are working with. So next slide, please. So as a recommended practice, anytime an overseas family member is located or expresses interest in caring for a relative who can no longer be cared for by their parents, a local social worker or a professional or accredited professional can be engaged to work with that family. ISS has a motto: cases travel abroad, not social workers. And that's very important to us. So in our recommended practice, we say the local expertise and advice will be required, but not limited to. So I'm just going to go through a few of our recommended practices. Consideration of legally available alternative cares in the receiving country will be detrimental to the possible placements. Like Elaine said, not all of our assessments will turn out to be placements, but if we're going to be working towards that placement, we will need to have some legal advice and to know what is available in the receiving country. So that's going to become very, very important, and we can use that expertise from that professional overseas. Local experts also understand the legal frameworks that will provide insight on how to best proceed. So not only about the legal system, but also the systems that surround that legal system in terms of follow-ups and things like that. What can we put in place working together with two countries? How can we best make that placement happen? Cultural values and languages. That to me is one of the added value of ISS, and why I have been so involved in working with ISS and believing in this principle. I could be the best social worker in the world, but if I cannot converse with the people that I'm evaluating in the same language, or do I know about their cultures and their values, it is very difficult to me to do an appropriate assessment of their home for the possible placement. So again, utilizing the local professionals gives us that added value, that we can actually have a one-on-one conversation and immerse yourself into the assessment itself. Local systems and services to support the family as to explore placement. Again, if we are going to be moving towards placement, if the children have special needs of any sorts, if there's any medical requirements that we need to look into, again, the local professional will be the best suited person to let us know what services we will be able to tap into if that placement occurs. And of course, local professionals can also conduct appropriate background checks that will ultimately make sure that the home is also safe, that the family is not known to child protection agencies or even sometimes in the criminal system. Next slide, please. I want to get to a case example, so we will go really quickly. Again, what the local expertise can also ensure a deeper insight into educational and developmental opportunities within that new country that they would be moving into, social relationships, norms and customs, the community resources, the family's social integration, income parity and adequacy. That's again something we have often used our ISS partners to tap into that very important question of what does it look like to have an income that would be necessary to raise a family with an added family member in these cases, the housing parity and adequacy again, and the family history and functioning. So again, getting really involved with the family, getting to know them, and making sure we can provide a proper assessment. Next slide. So I loved Elaine's example, so I'm hoping my examples also do justice to how we use already in ISS these best practices. So we had an assessment that we had to do on a maternal grandmother in Asia. And we were working with a child protection agency here in Canada. And the home assessment came back from our partner in Asia. It was very, very positive. This grandmother was really much willing to have her granddaughter come and live with her and so on and so forth. But as I was reading the assessment, we found out that because we were sending this assessment back to a big city in Canada, and that shall remain nameless, I was noticing that there was big differences to what we are accustomed to in this big city in Canada compared to what was being described in the home assessment from our partner in Asia. So I asked for an addendum from our partner in order to explain, what does this mean when you mention that there's different types of plumbing and maybe different technology that we would be used to and that was not set in place in that particular remote area? And so the partner was very much willing to explain a little bit more, explain how it was safe, explain how the system is in place, how it was a normalcy, it's a normal procedure, it's a normal thing to have in that part of the world. And so I was able to add the addendum to the assessment. And when it was sent to the local child protection agency, they did not even think twice that this opportunity for this 2-year-old was more than adequate, and they had appreciated that we had explained further what this home was like and what was normal for this part of the world. So a huge added value when we were able to do this assessment and this ultimate placement in this case. I pass on to my colleague for principle number 4.
Hi there, everyone. Hi, I'm Carolyn. I'm going to be taking you through our 4th principle, which is really about ensuring that we remove bias. So I hope that we all know that we must work to address implicit and unconscious biases, particularly because they may manifest when we're navigating complexities in transitioning a child into a family placement overseas and within a system or culture that is different from our own. Now, this principle is very much based on Article 2 of the United Nations Convention on the Rights of the Child, which is that every child has rights without discrimination of any kind, irrespective of the child's or his or her parents or legal guardians' race, color, sex, language, religion, political or other opinion, national, ethnic, or social origin, property, disability, birth, or other status. Next slide, please. So you may be wondering why we felt the need to address bias when child protection practitioners often do this as part of their practice. The truth is that the ISS Network's cross-border casework experience reveals deeply rooted racial and ethnic biases, as Julie alluded to earlier, and this contributes to significant hurdles that certain children encounter in achieving permanency with family. So we know that presently there is no equity for children in permanency. Biases may also extend to how social work or child protection casework occurs in an overseas country. So social workers and decision makers need to be culturally aware and sensitive to how assessments and casework may differ in countries overseas. Sylvie alluded to this a bit just now. And this may include assessment frameworks used, how background checks work, police and child protection checks, how they occur, and even the living or sleeping arrangements in the prospective carer's home, which may be very different to what the particular social worker or caseworker experiences in his or her own country. So we need to be very aware of all these cultural differences, our own implicit and unconscious biases when focusing on the best interest of the child and conducting child protection casework activities on all levels. Next slide, please. So to really illustrate this point, I have included here 2 photos from a home assessment undertaken for a child in Australia. One relative was in England and one relative was in India. Now, just looking at just those 2 photos, you may already experience a personal preference for which back garden you would want a child to have. You might see one garden as tidy and safe and the other one not. You might see one garden as large with potential and the other as too small and lacking privacy. So we all have our own prejudice, but we mustn't allow this to overtake what actually is in the best interest of a particular child, a child who needs to be safe and loved first and foremost, but also a child with an identity, a culture, with roots and a need for belonging. Each of our principles also contained recommended practice, as you've seen. So for our no bias principle, we believe that child protection systems should promote training on systemic, individual, and implicit and unconscious biases for professionals working at all levels. Decision makers must develop a keen awareness of how institutional and historical practices continue to influence whether or not an overseas kinship placement is viewed as viable. Next slide, please. So there are a number of areas where individual or systemic biases may be hidden. That includes race, culture, identity, nationality, immigration status, to name a few. And this is why we believe it is crucial to create new opportunities to move from the discourse of protection towards building capacity for child's rights to guide practice. Child protection systems and NGO partners must evolve their policies and practices to fully explore family and kinship placement options when a child can no longer be cared for by their parents without discrimination of any kind. Next slide, please. So this isn't just an ISS observation. Family for Every Child, a completely separate membership organization, also recently published their guide on supporting kinship care, drawing on examples from around the world and based in the rights recognized in the UNCRC, much like our own principles. The guide is crucial to point out because it will help professionals understand what kinship care looks like in different countries, why it looks like that, and how children can be supported in different contexts. So do check it out. I think I'm handing back over to Sylvie now to talk about our 5th principle.
So as you can see by now, we've really pushed to have our 5 principles to really, just like Caroline just said, rooted into the child's rights. And this is no different for the 5th principle, which is, I'll read it out loud, and it is inspired, of course, and goes in line with the Articles 3, 8, and 20 of the Child's Rights Convention. So child protection systems should prioritize a child's access to their culture, their roots, their language, extended family, community, and traditional land when making placement decisions. This approach respects the child's right to a robust family life and affords them the opportunity to maintain their identity. Next slide, please. So our recommended practice, as you would imagine, is also we would recommend that you get familiar with the UN guidelines of the alternative care for children, but just like Caroline just said, we're not the only ones pushing for this, that have observed that this kind of principle is very much needs to be put in place. Every country's child protection system should explore all potential placement options that enable a child to remain within their extended family and cultural systems, including the exploration of any potential family placement options overseas. In my own country, before I finish reading off this principle, I happen to know that because we have such a big country and that we're divided into provinces and territories, that even within our child protection systems that are often much municipal, if we can look at it that way, would not even look at other provinces for placement. So again, to that same example that Elaine said, we're child protection authorities are not trained to look beyond the borders and even within some of our own countries. So we really want to push for us, for ISS. It is about looking at overseas when it comes to that, of course. When deemed in their best interest, that's another thing we have to push. We have to make sure that if this placement overseas needs to fit with their best interest determination. This also applies to cross-border kafala placements. You will see throughout our principles when you read the 9-page document that we've included to make sure that our principles also attach to the kafala placements when possible. And where overseas solutions may have to be a priority over national placements in case for families, a strong family ties. On to the next slide. So I will go right into a case example because we are running short on time. For some of you who may be familiar with the Canada and US border, it's a very long border that we share, and we actually have a law in place to allow our Native communities to go beyond borders without consideration of immigration. So it's a special treaty that we have, and that allows us to sometimes place children with kin in an easier way because we don't have to consider immigration, because as we've mentioned, immigration may play a role in our possible placements. So for this case example, we had a child in care living with a foster home in Canada, but there was a family that expressed a strong desire to have the youth come and live with them in the US. And I have to say, it was a beautiful example because everybody wanted this child. So sometimes when we have a hard time finding families, in this case, we had two communities who really wanted this child. And this child, being Canadian, raised here, had a certain attachment, but there was the opportunity to have this family in the US have him come and live with them. So we had to engage multiple partners to make sure that we were making the best interest determination. And because the foster home that he was growing up in was not necessarily rooted into his identity, there was a big push to have him go over to the US and be with his relatives. And of course, that, like Elaine said earlier in her case examples, we're talking briefly about a case example, but let me tell you, it was months and weeks, and a lot of thought had to go into this. But ultimately, in this case, the best decision was in favor of the identity. But we also made sure that there was a continued relationship with the relationships that this youth had made in Canada. So making sure he had the best of both worlds and that his identity was also put in the forefront. So this is one of the examples, and we have a multitude of them where we do have to consider identity when we are making best interest decisions. So on to our next principle.
It's me again. So I know we are running on time, so I'll try and be brief, but the sixth principle is about adequate planning, which really is around encouraging protection systems to prepare a child for impending placement with family overseas through the development of a transition plan that includes pre-placement support and local post-placement follow-up with connection to resources. Next slide. And so very much connected to the principle is the practice of having a comprehensive transition plan that includes pre-placement support, time-bound contingency plans, a clear plan to safely move the child to the new home, which includes having a suitable travel companion, and that the plan should include post-placement support to ensure that the child's transition and the cares are well supported from the outset. And I know in glancing at some of the attendees, I know there are some people on the call who've worked with us on some of these cases, so I'm glad you're all here. But in thinking about the kind of transition planning as a best practice, rather than present a specific case, I wanted to actually present for this a tool that ISS USA developed called the Community Resource Assessment, which began as an assessment tool, but really has become something we've seen very effective in using as a planning tool, and specifically a transition planning tool. And so with the Community Resource Assessment, the local social workers are completing both a checklist and a narrative about a community to which a child may be placed or returned. This is happening as part of an assessment process. So it's based on child-specific referrals that we get that have full case background on the kind of what's going on with the child and the family. And it's meant to obtain community-specific resources that can potentially support a placement, as well as risk factors there that connect to those child-specific needs. So I think this really also connects to that no bias principle. We're not looking and saying, making a decision based on what we perceive to be available in a particular part of the world, but it's really based on what somebody who is locally trained and professionally able to do is going to research about what are the resources there. And so in this tool, there's also space to note specific service providers, contact information, notes on contextualization, so we can really think about it as serving as the foundation of a service plan in the event that a child is reunified or unified with family in that particular community. So we've seen community resource assessments requested and particularly useful where the child and family have had a longer period of separation or potentially limited previous relationship, where there are noted medical, mental, or behavioral health concerns for either the child or members of the receiving family, the caregiver. We see a lot of these requests when there's a history of substance use disorder or involvement in the criminal justice system to see what resources are available to support those needs. And then in general, when a child is likely to be placed with family in another country where we don't know too much about what's there to stabilize the placement. So we use the community resource assessment to both identify the kind of pre-placement support for caregivers and to provide post-placement monitoring that has really clear and specific resources that can stabilize in medium and long term. And so when we receive a request from an agency to help reunite a child with their family in another country, we always advise them to get a community resource assessment along with the home study, which is pretty typical. And then also to request travel coordination assistance so that the reception in that home country is coordinated, accompanied, and safe. And so in the past year, we've really packaged some of these services together as a reunification service so that transition is, like I said, very coordinated. And I use this as an example because we do recognize that planning for a child's placement in another country, somewhere that is foreign to us, can feel like kind of uncomfortable at best, but we've also hear words like risky or dangerous. And so this is just a reminder that there are tools and resources out there to make sure that these plans are based on objective information and also have the safeguards in place to protect children while we are promoting their right to family life. And then I think on to Carolyn for the last principle.
Great, thanks, Lane. Last principle, and I will be quick. This is really on accountability. Child protection systems should seek to improve data collection, information management, and reporting systems related to children without parental care in all settings and situations to close existing data gaps and develop global and national baselines. It doesn't sound very exciting, but I promise you it's really important. It's really based on our own national experiences of collecting data on children deprived of parental care and the lack thereof it, but also is reinforced in the 2022 Kigali Declaration on Child Protection and Care Reform, to which more than 50 countries are signatories, so it should be a priority. Global research indicates that children have a greater capacity to thrive when they are raised in families of origin, whenever it is safe and in their best interests. But my question for our participants here today is whether you could accurately state the number of children in your country who have family members overseas. How would you go about getting that data? Could you describe the metrics used in your country to ensure children's right to cultural identity and roots is upheld? So Julie mentioned at the start that 281 million people are living outside of their country of origin. As a result, millions of children will have family connections that cross international borders. Our ability to move across borders has increased exponentially in the last 50 years, 100 years for ISS, but child protection frameworks have not adjusted quickly enough for this. And I'd just like to very quickly contextualize this for you, drawing on our own research here in England. So if we can go to the next slide, please. You know, what proportion do you think of children in England have a foreign-born parent? Just in your own minds. You can put it in the chat if you'd like to, but you know, think in your own minds. And what proportion of children in English care were actually reunited with family overseas in 2022, the same year that we know 281 million people are on the move around the world. So somewhere between 25 and 33% of all children in England have a foreign-born parent. I've looked at data from the Office of National Statistics for the last 20 years, and it's always over 25%. More recently, it's been 33%. This doesn't necessarily mean that children have family overseas, but it also doesn't account for second and third generation migrant families. So in reality, in England, it is closer to 50% of children have some international links. Big number. But what proportion of children that are taken into care reunite with family members overseas? So based on our own Freedom of Information research, and I believe the link to that paper was put in the chat earlier, and based on data supplied by local authorities, the percentage of children reunited with families overseas is around 0.04%. 0.04%. So that's less than 0.5% of children in care are reunited with families overseas. And we know from partners research in the United States and Australia that they have very similar results. So we know that the scale of children affected by discrimination of other cultures, other family structures, etc., is very large. But when we start asking systems to be accountable, to start recording data on these children, we see that so very few are accessing their right to family when those family members are outside of their country of origin or country in question. Let's look at the next slide, please. So this principle also comes with recommended practice, and really this is that child protection systems should be able to account for children they are responsible for, including the recording of when and where children are placed out of their jurisdiction, including across international borders. This will allow responsible organizations to analyze trends and improve outcomes for children. It is important to establish systems for quantitative data collection as well as qualitative data, including opportunities to gather knowledge and expertise from children and adolescents. In light of the informal nature of many cross-border kafala placements, for example, data collection and effective monitoring across borders is really of utmost importance.